Let's dive right into what is literally the gold standard for quashing criminal proceedings in India. State of Haryana v. Bhajan law. If you're a law student prepping for exams or just someone fascinated by the gears of the Indian justice system, you're in the right place. We're going to break down the legal principles of this landmark case so they're absolutely crystal clear.
Here's our roadmap for this explainer. We'll start with the facts of the case, move on to the core legal issue, and then weigh the arguments from both the state and the respondent. After that, we'll hit the famous 7 definitive guidelines, apply those legal tests, and finally look at the landmark judgment itself. Let's get to it.
Section 1. The facts of the case. Let's set the scene with a bitter political rivalry that sparked a massive, system-altering legal battle. Picture this. It's 1987. A political rival files a serious complaint against Bhajan Lal, the former chief minister of Haryana. The allegation? That he'd racked up massive, disproportionate wealth. We're talking crores of rupees, completely out of sync with his known income. Bam, an FIR is immediately registered under the Prevention of Corruption Act in the IPC. But here's where it gets wild. The superintendent of police, the SP, scribbles a hasty, handwritten note just telling a basic police inspector to go investigate. Bhajan Lal doesn't wait around. He marches straight to the High Court, arguing this is nothing but a political vendetta and, procedurally, totally illegal. And you know what? The High Court actually agrees. They completely quash the FIR right out of the gate. Obviously, the state of Haryana isn't happy about this threshold dismissal, so they appealed directly to the Supreme Court.
Section 2. The core legal issue. What's really fascinating here is how the Supreme Court had to unravel the exact legal puzzle at the center of all this chaos.
Before we go any further, we really need to define Section 482 of the Code of Criminal Procedure, 1973. This section, along with Article 226 of the Constitution, gives high courts what are called inherent powers. Basically, this means the High Court has this overarching authority to step in, prevent the abuse of the legal process, and secure the ends of justice. They can do this even if there isn't a highly specific rule written down for a unique situation. It's a massive amount of power.
So the crucial question we're investigating today really boils down to this. What are the precise legal boundaries and guidelines governing those inherent powers? When can a high court legally step in and just kill an investigation before it even really begins? I mean, if the police have a statutory right to investigate crimes, how much power does a judge actually have to say stop right at the threshold?
Section 3. Arguments. State versus respondent. Let's look at how this intense tug-of-war between police autonomy and judicial oversight played out in the highest court of the land.
The competing priorities here were absolutely fierce. On one side, you have the state of Haryana demanding unhindered investigative powers. They argued that if an FIR shows a prima facie, meaning on its face, cognizable offense, the police have an absolute, independent, statutory right to investigate it. They said, look, if a complaint is fueled by political rivalry, that's a fact you discovered during the investigation, not a reason to just toss the complaint out on day one. On the flip side, Bhajan Lal argued that the FIR was a textbook abusive process, completely manufactured by his political enemies. But even more importantly, he pointed out a fatal procedural flaw. He argued the investigation was legally void right from the start because a lowly inspector was authorized via a super casual handwritten note. That completely violated the strict rules laid out in the Prevention of Corruption Act.
Section 4. The 7 definitive guidelines. Okay, we've arrived at the absolute meat of this explainer. This is where the Supreme Court brings order to the chaos.
But before handing down the rules, the court established the underlying philosophy. Justice S. Ratnavel-Panyan beautifully articulated that judges really shouldn't be acting as investigating officers or an appellate court at such an early stage. He stated that this interference is an extraordinary power, one that should be exercised very sparingly with extreme circumspection and honestly only in the rarest of rare cases. The logic is simple. If you destabilize the police's statutory right to investigate, you kind of destabilize the entire justice system.
To bring some much-needed structural clarity, the court formulated 7 illustrative categories where an FIR actually can be quashed. Let's look at the first 4. Notice how heavily these rely on the simple face value of the FIR. The court's job here is basically just to ask, if we assume every single word in this document is 100% true, does it actually look like a real cognizable crime occurred? So, if the allegations taken at absolute face value don't constitute an offense, or if uncontroverted evidence fails to show a crime, the High Court is completely justified in stepping in. Similarly, if the allegations only describe a non-cognizable offense, but the police are just investigating anyway without the required magistrate's order, those proceedings can absolutely be quashed.
Moving on to the final 3 guidelines, these address situations that go beyond just missing the elements of a crime.
Guideline 5 deals with sheer absurdity. We're talking claims so inherently improbable that no prudent person on earth would ever believe them. Guideline 6 is all about explicit legal roadblocks, where a specific law expressly bars the institution or continuance of proceedings. And then there's Guideline 7, which is absolutely crucial for this case. It allows quashing what the proceeding is manifestly attended with mala fide, basically undeniable, malicious intent aimed solely at wreaking personal vengeance.
Section 5. Applying the legal tests. So, let's dive into how the Supreme Court actually applied these brand new rules to Bhajan Lal's highly specific situation.
Let's break down the court's thought process step by step. First up, did the FIR show a prima facie offense? Yes, it did. The Supreme Court said the High Court severely crossed its boundaries by evaluating the merits of the evidence before the police could even collect it. Okay, second, what about the political malice? The court ruled that a personal grudge or the malice of an informant simply cannot invalidate an otherwise legitimate disclosure of a cognizable offense. So based on those 2 points alone, the FIR survives. But wait, let's look at the third issue, the procedural flaw. Here, the court entirely agreed with Bhajan Lal. The statutory safeguard requiring a senior officer to authorize the investigation, that is absolutely non-negotiable. That casual handwritten note by the SP was legally defective, no two ways about it.
Section 6. The final landmark judgment. Let's look at the ultimate resolution and see exactly how the court split the difference to uphold both the letter of the law and the strict procedures required to enforce it.
The Supreme Court elegantly reasoned that a procedurally defective investigative direction doesn't just kill the FIR itself. So, in Step 1, the FIR survives, which completely overturns the High Court's threshold dismissal. In Step 2, they explicitly declare the initial investigation by that basic inspector to be procedurally illegal. And that leads directly to Step 3, which is a brilliant compromise. They ordered a fresh, rigorous investigation to be conducted by a legally authorized, high-ranking police officer, strictly complying with the Prevention of Corruption Act.